Bruce McIvor.
Thank you, Justices. On behalf of the Indigenous Bar Association, I want to first try by doing my best to dispel a bit of the smoke that I think has arisen there in the court today. And this goes to one of the questions posed by Justice Rowe. What is the question on this appeal? And I think you have to start with what are the salient facts. And the two salient facts from my perspective are, first of all, Sinixt territory predates the assertion of sovereignty and the establishment of the border. Second, Sinixt exist on both sides of the border, Sinixt people. And for your reference, you can refer to paragraph 58 to 69 of the trial decision. Very importantly, what was not decided. The courts below did not decide the precise extent of the successor group that exists today. The trial judge said that the Lakes tribe of the Colville Confederacy are a successor group, not the successor group. You'll find that at paragraph 68 of the trial decision. I think the best explanation is found at paragraph 49 of the Court of Appeals decision, that this question of the modern day successor group was not decided at the courts below. And it's important to keep in mind why that wasn't decided, because this isn't a action. This is a defense to regulatory charges. And as the court has observed before, it raises problems when you bring these types of collective rights forward as a defense to regulatory charges. So when we keep the question in mind, it's not, as you heard from the appellant and the Crown interveners, it's not a question of a foreign rights holder group asserting rights in Canada. That's not it. The way I would phrase it is the question is whether a person of Indigenous ancestry who is a resident of the United States is entitled to exercise an Aboriginal right in their people's ancestral territory in Canada. Once we keep that question in mind, I say that a lot of the arguments that you heard today are for another day. It's important to keep in mind here what's happened. This arose as a defense to the regulatory charges. Mr. Desautel brought his defense. Notwithstanding the fact that this was described as a test case, we are here today because Indigenous people across the country are regularly forced into court to defend their rights. Too often, the Crown responds to their claims with arguments that would, if accepted, narrow and defeat the promise of Section 35. And I think that's exactly what's happening here in court today. The second point I would like to make is about so-called practical challenges. Decolonization is a messy business. That's why it's a road, not a moment in time. The assertion of Crown sovereignty, rooted in the discredited doctrine of discovery, puts a heavy burden on the heavy burden of reconciliation on the Crown. Let's keep in mind what's happening here. Instead of shouldering this responsibility, the appellant and Crown interveners are relying on the ultimate expression of colonization, the international boundary, to lessen the burden of reconciliation. This court should soundly reject those arguments. Just as in Delgamuukw and Vanderpeet, it rejected earlier arguments that an unbroken chain of continuity is required to prove Aboriginal title and rights, because doing so would undermine the very purpose of Section 35. I want to make a last point about why this case is so important. From my view, the grand purpose of Section 35 is the distinctive peoples that Indigenous peoples that predate colonization and the creation of Canada are to be protected and perpetuated into the future. Distinctive Indigenous peoples, including the Sinixt, continue to exist along the border across Canada, despite the bifurcation of their territory by the international boundaries, and despite the devastating effect colonization has had on their lands, languages, cultures, political systems, and families. They have survived. Section 35 was intended as a bulwark against the ultimate success of colonization. On behalf of Indigenous lawyers, law students, scholars, and judges across Canada, I urge this court to uphold the promise of Section 35 and not to become the instrument of completing Canada's colonization project.
Thank you very much. Thank you. Maxime Faille.